Okay, well, thank you everyone for joining us today. My name is Stephanie Cohen. We're here today to talk to you about the new ICC Commission report on leveraging technology for fair, effective, and efficient international arbitration proceedings. At the outset, let me thank Silicon Valley Arbitration Mediation Center for hosting this webinar, as well as Brian Cave doing the virtual hosting for us today in the registration, and our media sponsor, Ojamid TDM. I'm going to start off by giving you a brief sort of roadmap of where we're heading and a little bit of background about the ICC Commission that prepared the report and the working group. But the rest of our time today, we really want to have a roundtable discussion. And I know that attendees are continuing to join. You might have been slowed down figuring out where your bar number was for CLE on that registration form. I know that gave me a pause. But we do want to invite you to put comments in the chat and in the Q&A. And because this is a roundtable discussion, we will do our best to keep our eyes on all of the different places across our screens in order to be able to incorporate those comments as we go. So don't be shy. Okay, so a few words to begin about the ICC Commission on Arbitration and ADR, and then I'm going to introduce you to my colleagues. The ICC Commission on Arbitration and ADR is a global body that's comprised of 850 members from over 100 countries that brings together experts and practitioners in the field of arbitration and ADR to bring awareness to practical issues, and it plays a consultative role in vetting proposed changes to ICC rules. Typically, the Commission works through task forces that issue reports on subjects such as the accuracy of fact witness testimony, techniques for controlling time and costs, or the use of technology. In our particular case, there were a number of prior reports on the use of technology in international arbitration. And not surprisingly, with the onset of the pandemic and acceleration of digitalization in international arbitration, the Commission's executive committee determined that it made sense for there to be greater guidance on the use of technology and convened a small working group comprised of only 12 of us this time, so not one of the larger task force that normally gets convened, but a working group of 12 to update an existing report on technology. Eventually, we expanded on that mandate, recognizing that there was a lot more to do than just focus on changes that were happening at the outset of the pandemic. And so what you'll find in the report, and I'm going to put a link in the chat as we kick off the discussion, is that the report really focuses on trying to give an overview of where technology is being used today. We can talk a lot about future applications of technology. We determined that it made sense to focus on the current state of play, in part out of a need to raise the level of awareness across the board and level the playing field. And so the report includes both sort of a text on principles and guiding principles and background sections, explanation, but then has a number of practical resources, checklists, sample procedural language in order to facilitate use on a ready basis. So that is your general kind of overview. We're going to talk about a few of the issues that are covered in the report, not all of them we couldn't possibly, including paperless proceedings, applications of artificial intelligence, and remote hearings. And as I said, we're going to have this in a roundtable format. So I have with me three colleagues who were on that working group, all members of the Silicon Valley Arbitration and Mediation Center. We have today Cle Morel, who is a partner, Cle Morel de Westgaver, who's a partner at Brian Cave, Leighton Paisner, Mark Morel, who's an independent mediator and arbitrator based in New York, David Wilson, a member of Sherman and Howard, also acts as arbitrator and counsel, as does Claire. So you have everybody on this call today acts as both arbitrator and counsel, and was deeply involved in working on this report. Your CLE code, your starting CLE code, there are going to be two during this program, is 312. So the CLE start code is 312. 1, 2. And with that, we're now going to get into that roundtable discussion. So my first question to kick things off is for Claire. Claire, what do you see as the prevailing issues and challenges for both parties and counsel and arbitrators, on the other hand, in seeking to leverage the use of technology in arbitration proceedings today?
Thank you, Steph, and thank you for the introduction. So for me, Steph, the main issue is really to ensure that the technology generally and the relevant tool that one might be talking about is indeed required and the most appropriate one in the circumstances, and that it makes effectively arbitration better rather than worse. And when considering the digitalization of arbitration, I like to remind myself of the perceived advantages of arbitration. As you know, they include flexibility, finality, confidentiality, enforceability. And so for me, the prevailing issue is to ask oneself, this piece of technology, will it actually help users and participants to leverage those advantages, or actually, will it be the reverse? Will it hinder actually, arbitration? And so I'll give you 2 examples. I'm sure they can be challenged, but hopefully they illustrate my points. I think, as Steph alluded to, I'm sure you will all agree that the use of technology, and particularly video conferencing facilities, has helped users, counsel, arbitrators all over the world to leverage the flexibility of arbitration during the pandemic. So that's one example. It's positive and it's helping users to leverage the benefits of arbitration. Second example is the fact that the use of technology generally actually does give rise to certain new risks, including cybersecurity risk. And we discussed in the report that if those risks are not tackled, actually, this could give rise to a problem, including, cyber risk could actually jeopardize the confidentiality or the confidential nature of arbitration. So just another example to show that, we have this process that has some benefits, and to me, this is what we're trying to do in the report, is really helping users, making this exercise of weighing the pros and cons of technology generally and particular tools, and also keeping in mind due process considerations. So hopefully that's the report will help in that regard, because it's not it can get quite complex to assess those tools, and then of course they keep coming, the technology keeps evolving. So that's what I would say about what the main issue is for me.
David, do you want to add to that?
Yeah, sure. Thanks, Steph, and thanks for everybody for joining us today. For me, that really the key is how to think about using technology. Technology is a tool. It shouldn't be used just for the sake of using it. And so the question is, will a particular technology application save time and costs? Will it help the arbitrators and the parties to focus on the disputed issues in the case? Will it help the panel better to understand and resolve those issues? And will it enhance or detract from equal treatment of the parties? And then, as Claire points out, are there downsides like increased risk to confidentiality or other complications in terms of data protection requirements, for example?
Mark, when we were focusing on this, there were 2 things that I know often are dear to your heart. One being the so-called digital divide, and the other thing, thinking about practical resources and sort of the idea of having a toolkit. Can you give us a little bit from your sense about how and why we address those things in the report up front?
I think the orientation of the report is very practical. We did work very hard and I think achieved the digital toolkit. I think and you see that in the checklists, the appendices, and in the text of the report. I think it speaks to the fact that as a technology community, I don't think we've done a good job of communicating to our various constituencies that the most important tools really are very accessible. They don't require significant technological sophistication or expertise. They don't require significant monetary resources. And I hope that our report will try to deliver the message of accessibility as we did in the cybersecurity protocol. Generally, I think the top of mind issue for me at the moment is, I think, the risk of backsliding from where we are. We've just had the unfortunate experience of conducting a worldwide experiment in the use of virtual technologies. And by and large, it worked amazingly well. So we don't know what the new normal is. We certainly are hopeful that we're entering a somewhat post-pandemic phase. And I think arbitrators in particular really need to speak up to share their experience with virtual proceedings and their experience with a lot of the tools that are in this report. And I think by and large, at least my message would be, and I suspect the message of many of my colleagues would be, that this worked really well. We're the ultimate audience for many of these things, and we are receiving what we need to know to adjudicate these matters at least as well, if not better, than in person. So I think that we're at an inflection point, and I hope we can use this report to keep things going and increase the utilization.
So, I mean, it's interesting you talk about, what did we do well during the pandemic? We started to use the technology, but really, what can we do better? And in David and Claire, Mark just, focused on the communication piece in part, sending out the message that there are readily available tools and raising general awareness. What else do you think we should be doing better as an arbitration community in trying to use technology to our advantage? What do we need to improve on in order to meet the inflection point?
I mean, I think you need to be humble. It really works on a case-by-case basis, right? So, in some cases you might not need, a case management platform. In some of the cases you might not need, encryption. In some of those cases you might not need to have the awards signed electronically. I mean, so I really like the word leveraging technology in the name of the report, because it goes back to whether you need it or not, and is it appropriate. But also, if it is appropriate, it's a matter of, in my view, being humble enough to revisit, to review what we've been doing for years, and challenge the done thing. In the last few decades, we've seen a trend in arbitration, which I call the standardization of arbitration. Parties arguing, counsel arguing, before tribunals that this is the standard way of doing things. I think what the pandemic showed to us, that actually, why don't we just challenge ourselves and review all those standards and use the flexibility of arbitration to really adapt, and one way to adapt is to use technology. And so being open to new applications, whether the suggestion comes from the other side or arbitrators, and kind of embrace the tools that are available. So that's my take on that.
So I agree with that. I think really the key is the willingness of the parties and the panel to embrace new tools that may save time and cost and do the other things that I said previously. So, for example, paperless proceedings. I mean, we historically would not have considered that. I'm admitted in England and Wales, in addition to Colorado, believe it or not. And if you've ever been in an English court, you're familiar with the bundles, right? And so you have the solicitors preparing literally correspondence, pleadings, case authorities, everything to go to any hearing with the court, and the judge stacks these rows and rows and rows of stuff up on the bench, and then the barrister says, "My lord, please turn to volume 7 of the bundles, page, whatever," and it's very tedious, and it goes on and on and on. And we've seen that kind of experience repeated in arbitrations, right? Particularly in certain international cases. And it increases because of the need to manipulate the paper files. It causes the hearings to be longer. And so we don't have to do that anymore. And we can at least exhibit exhibits or show exhibits digitally or project them on a screen. And so the question is, can we have entirely paperless proceedings? And so we have this survey that we did in connection with our report, and 63% of the folks surveyed said that they would be comfortable with paperless proceedings, except in connection with the hearing. And so really the question is, okay, well, can we go entirely paperless? And I would say, in my experience, paperless proceedings or near paperless proceedings are certainly more common. Some arbitrators are resistant to going entirely paperless because they like to take notes on the exhibits. Certainly, I've done that in the past, although I guess I'm becoming more comfortable just dealing with the PDFs, especially as we, more and more operate in a virtual environment, working remotely and that kind of thing. So, but there is an issue of fairness, right, for the witnesses. Should the witnesses be able to look at the entire document, to page through it with the document in front of them, rather than only being able to view the portion of the document that the lawyer is directing the witness to focus on in connection with a particular question on direct or cross-examination? And so I think that in most commercial settings, we're probably never quite going to go to a true paperless setting, but at least in many cases. But we're moving more and more in that direction.
I think it's fair to say that from the approach that the report takes in talking about paperless proceedings and really all issues is that we put a high emphasis on early case management and identifying some of those factors like you just mentioned, David, fairness being a big one, ways to think about these issues in order to come about one result. But let's take it back to what can we do better? How are we going to move forward? We know from the report, which included a global survey, that there is greater willingness to be paperless going forward, right? So people have said, at least that from their experience in the pandemic, they're willing to try things differently. Mark, in your experience, talking to colleagues as arbitrators who might be resistant to having more of a paperless proceeding, what are some of the concerns that you hear being raised? How have you addressed them when they've come up?
Well, I think to that point, first of all, the issues that David and Claire just flagged are indicative. I think we need to identify issues because most of the issues can be readily dealt with on a technology platform. So if you give a witness an electronic bundle, counsel representing that witness needs to be able to assure the witness that if she or he needs time to page through it, that they just need to say they need to do that. In terms of my experience with resistance and utilization, I think we live in a bit of a bubble where we are comfortable with these things. I don't think that's true across the board. I see that Jonathan Fitch and Theo Chang are on the call. They know that in another context very recently, I did a little SurveyMonkey survey of a group of sophisticated, in most cases, arbitrators about some of their technology and note-taking practices. And the results, I think, are probably pretty indicative of the broader population of arbitrators. 80% of those people rely primarily on handwritten notes. Very few of them use PDF markup tools that are described in section 4.4 of our report. Of the ones who used PDF markup tools, almost all of them used Adobe Acrobat Reader, which has very limited markup functionality. A very small handful used Notability. No one used PDF Expert, which is the one that I use. And I know you use too. That's not a coincidence. I think that we're still very much in a realm of fear of the unknown and underutilization. And I hope the report can help with that, because I think certainly the management of PDFs, the utilization of PDF markup tools is, I think, really the closest thing, in addition to virtual hearings, to a breakthrough technology in our space. The idea of not having that bookshelf with the 6-inch thick binders that law firms insist on sending to you, and shuffling through them and having the rings open and the papers scatter all over the floor. I mean, that is just a really bad technology as compared to what we can readily do now in a proceeding. And I think arbitrators still are not quite there.
As you say that, I look at my 2 large screens with my laptop for my 3-screen display, and then my two iPads, because I do mark up the documents and use another one as Notepad. You will find very little paper in my office, but I've never been happier after getting the second iPad, I will say. So I think, as Mark, you pointed to the section in the report, but the key there is that in trying to identify some of these tools, one of the things that we did is, rather than trying to promote one particular product versus another, all of those things change, and the ones that you mentioned are just examples to give people ideas of things that colleagues are using, because that's one of the biggest questions, isn't it, that comes up, is they've been using, we use the same tools, we get used to using the same tools, and we don't want to move to something different. So if Adobe has worked for a gazillion years, why would I look to something else? So trying to flag some of those things. This sort of turns, there's the arbitrator piece of it, the arbitrator being comfortable with it. There's the witness, as we talked about. Claire, what about in terms of clients and parties? What do you think party expectations are today in terms of arbitrators' technical or technological competence? Are your clients concerned about this? Is it something that you consider when you're making recommendations about arbitrator selection?
Yes, this is something that we consider, and that we take into account, and we talk to our clients about this, whether themselves are aware of this as a factor, and whether they do consider the level of knowledge of IT when it comes to arbitrator selection. Really varies at the end of the day. It varies on the nature of the case. It varies on the risks, and the profiles themselves. But I have to say, for me, the trend and the real change is that it has now become a factor, which I think until 5-6 years ago it was just not a factor at all. So I think that's quite interesting. I mean, I should disclose the fact that a lot of the disputes I get involved in, like most of us in the audience and on the panel, has a technology element. So obviously, clients tend to be quite tech savvy themselves, and they often require knowledge of technology or general, tech savviness from arbitrators. But generally, that is more for the purpose of the outcome of the arbitration, as opposed to the conduct of the arbitration. But as I said, it is starting, and to me, that's encouraging, and it's an interesting trend when it comes to also broadening the pool of arbitrators. I mean, we do have a lot to learn from the new generation, I think, of arbitrators when it comes to the use of technology. Having said that, in my experience, the more tech-savvy arbitrators are not necessarily the younger ones. But I think from a diversity and cognitive diversity perspective, and richness of debates, and the best process and the best outcomes, I think it's interesting to see this trend, because it just offers an opportunity to broaden the pool, as I said.
And interesting that it's another topic that the survey revealed is something being considered. So not the number one consideration, not to replace other considerations, but it's now something that you have to be cognizant of. So in that respect, David, I'm just sort of curious as how far do you go in your practice when this issue arises, in either representing parties and sort of saying to arbitrators who want to have all the paper to smile and suggest, is this something that we could do electronically, or do you just always go with what the arbitrator requests, and obviously there could be good reasons for doing that, and how do you deal with your colleagues if someone's not inclined to do it? Do you make nudges, or what do you do?
Well, so on our survey, 51% of the respondents said that they think that arbitrator tech competence is a factor to consider, and I think 40% said that it depends. And so for me, and this is kind of how I would answer your questions, tech competence is part of the entire skill set that an arbitrator needs to apply to have effective case management. And so if I have a colleague on a panel, or if I'm counsel and I'm dealing with arbitrators, one of the things that I'm interested in really are, the three questions that I posed at the beginning. I mean, does the technology help to save time and cost? Are we focusing on disputed issues? And is the use of the technology going to assist the panel? And so if you have somebody who says, well, I don't want to use technology, or I want documents to be emailed as well as paper copies transmitted, or something really old school like that, my question is, why do we really need that? Is there another approach that everybody would be comfortable with that would help save time and costs? And nine times out of 10, if not 98 times out of 100, I'm finding that both arbitrators and counsel are receptive to that, because everybody is relatively comfortable dealing with the electronic transmission of documents, dealing with PDFs, emails, whatever, rather than paper files and other things that would not have been as well accepted certainly 5-10 years ago, but even more so since that are more well accepted since the pandemic.
Okay, so we had a question about a slightly different topic, which is the extent to which we address in the report the need for parties to provide hardware and training to witnesses. And the question was, did the report address that? Now, I know the answer to that question, but I'm wondering, David, Claire, Mark, do any of you want to jump in on that one? If not, I will.
Yeah, go ahead.
All right. So in the first instance, this is an issue that we address. Moving aside from witnesses, in the first instance, we talk about specialized hardware and software. And certainly there's some cases, like you can imagine a construction case, for example, if there's specialized delay software that needs to be consulted or something of that nature, then that is an issue that has to be addressed up front. And we talk about having and convening special, training sessions or conferences to deal with that. In terms of witnesses specifically, if we're talking about remote proceedings, we're going to have a further discussion on remote proceedings later on in this program, but we have a number of checklists that we've included to help counsel when they're working with witnesses to prepare witnesses. And one of the issues that is raised up front is, to assess what a witness's technological equipment is, what equipment do they have for the hearing, what is needed, and the ability to supply some of that hardware from a third-party service provider. In terms of the digital divide and thinking about this from a global perspective, not the infrastructure isn't the same across the globe, and we're keenly aware of that. So one of the recommendations in the report on that front in trying to be attuned to differences in resources and sophistication is a suggestion going forward that we have more institutional cooperation, particularly in regions where there may be less developed infrastructure, that there is really maybe a need going forward, or there is a need going forward for greater cooperation to ensure that there are services available globally that can provide some of the hardware and so on. But let me just sort of interject there. What's been your experience in terms of the need to get hardware, for witnesses, whether it's been laptops or, having a second screen, for example, during the last couple of years? I know there are a number of third-party service providers that have, briefcase services to make some of this equipment available. Have you found that Claire and David, when you've been working with clients, that's something that you've had to take advantage of?
So I think third-party service providers are helpful. I mean, as an arbitrator, I don't want to have to manage the AV in the hearing room, right? And I think that in the previous iterations of the ICC's information technology reports, we've always assumed that there would be IT professionals or other technicians who would handle some of the more mechanical aspects of things. And I think that third-party service providers certainly are useful in that regard. Some of the institutions also provide some technology support in terms of hosting Zoom calls and that kind of thing. And I think those are good services to take advantage of.
Yeah, and so I agree. What I find was quite interesting was the additional issue of supervision, witness supervision in remote hearings. I think in most cases, depending on where the witness will, from where the witness will testify, in my experience, most of the time they have the infrastructure and it works. And if the witness is supervised in person, that's not really an issue. Where we had more complicated and more complex infrastructure provided by a third party provider, those cases where we needed that third party provider, I think generally related to specific circumstances where it was not possible for the witness to have, for some reason, their own infrastructure checked. We had one case where the witness couldn't be supervised in person for COVID and also other confidential reasons. So we had to, because it was a witness on the other side, our side couldn't supervise the witness, and it was high stake, lots of difficult issues to address with the witness. So we had to actually manage supervision via, a number of cameras. And of course, then the whole infrastructure was to be, needed to be agreed, which is quite tricky when the relationship with the third party provider is not just a unilateral relationship between one party and the provider, but actually everything needs to be agreed. And in my experience, that's kind of tricky, because you need to, of course, understand the technicalities to be able to agree, advise your client on those issues, and you just need to adjust to those situations. But yes, I mean, in those situations, you definitely need a third party provider, and in those infrastructures can really get quite complex to agree.
And so one of the other checklists that we have in the report is in Appendix C is just considerations for parties when choosing a third party service provider as a host. And so one of the questions in terms of pre-hearing technical support and equipment that we pose to try and help practitioners thinking about this in advance is what equipment can be provided to case participants if needed. So that's flagged there. Another kind of piece of this, Mark, I know that you have in some of your cases appointed an IT support person and proposed some procedural language for the report.
I think that, I agree with David and Claire that with a couple of things they said. One is that the ideal situation is where technology fades to background. And although I think the tribunal ultimately has responsibility to see that it's working, we do want to relegate a lot of it to service providers. And I think the use of the checklists in the report are important. So I have had procedural language that addresses the virtual hearing in some detail. There are a lot of model virtual hearing orders around. They're important to go through. Steph has done a very good one. There's one that CPR did, and all of the institutions now have provided guidance, and there's guidance in the report. I think Steph, you a couple of times flagged the digital divide issue, which I think is also relevant here. I think we have to be sensitive to it. Overall, I think that technology probably has more of a leveling effect than a divisive effect, but the risks are real. I sit on the board of a settlement house in New York City with a client population where the schools gave all the kids in the neighborhood laptops, but none of these kids live in a place where there's broadband access. So the laptops did no good at all. So, we certainly see issues like that in the arbitration space, and we have to anticipate them. We have to make sure that the third-party service providers are sensitive to them, and we need to address them.
I think one of the ways that we did that, I think through the checklist, was to try and take some of the overarching concerns about fairness and digital divide and put them in short sort of little snippets, because there's so much guidance that is out there. So going back to the communication message that you raised at the beginning, Mark, from my perspective, to kind of help people do this, it was important to kind of do it in bite-sized snapshots in a way that is easy to understand. So if we go to the council's pre-hearing checklist for preparing individual witnesses, for example, those issues are really distilled into little bolded topics on the left that you can just use as a quick reminder of things to go through with witnesses, and then a little bit more description. So reliable internet connection is one of those issues which Mark just flagged. Witness technical training is another one. Audio, video quality, and related equipment. So we go through all of those different things to try and make it easy so that you don't have to read all of these orders and so much information at one time, but be able to kind of distill it. So let me turn to ask another question. I'm going to note that Richard Levin has a hand raised. I don't think we had talked with Brian Cave about elevating people to become panelists to ask questions, but we could do that at the end, unless I see any objection from from any of my colleagues, and I doubt there's going to be any. So if that's okay with Laura, who's hosting, maybe when we turn to questions, Richard, if you would like to come on camera and pose your question, that would be fine. Or else, if you type it in the chat or in the Q&A, then we'll try and address it.
Jeff, I just want to add to what you just said, that I think one of the good things is that we're now seeing a very deep bench of service providers. That expertise is all over the place now. It's in the institutions, it's in almost every court reporter, and a lot of standalone providers such as Arbitration Place. And that's been a huge benefit. But I still think at the end of the day, the tribunal owns the process, and it's responsible for ensuring that it all comes together, even if someone else is running it.
So, let's focus on that point for a minute. It's not going to be surprising that I agree with that, Mark. But there seem to be different kind of views. We've been working on Zoom for 2 years, and it seems like some counsel don't want to do technical tests, beforehand. Arbitrators too. Some arbitrators, don't really want to have conversations with the third-party service provider. The third-party service provider is host, and why isn't that good enough? So let me sort of to drill down on that piece from kind of the theoretical, the arbitrator has a responsibility here, to what we've sort of seen in practice, to kind of turn to David and then Claire. Talk to us a little bit about what your experience has been in working with hearings, different styles that arbitrators have had, and working with third-party service providers, and what to you has really been important in terms of the nitty-gritty that the report kind of flags to kind of help shape that process.
Well, I think the issue is whoever is handling the service. I mean, are they competent, and is the technology going to work? And so I agree with Mark. It's ultimately the panel's responsibility to see that the hearing goes forward. On the other hand, it's normally the parties that, to the extent that they're using a service provider outside of an institution, that the parties are arranging someone to manage the hearing, or, for example, they're with their law firm to a certain extent, if they're hosting the hearing or handling certain of the technological aspects. And so if the testing before the hearing, I think is important, because once the show has started, if something is not working, then that almost necessarily is going to mean a delay in the hearing, which is frustrating and expensive for everyone. The issue of broadband bandwidth, I think, cannot be understated, especially when dealing with a remote hearing for people in certain parts of the world that, for example, in South Asia or other places that literally are, on the other side of the world where I am. And so I think we in the West assume that everyone is going to have these light and fast speeds, and there's going to be no latency or other, problems with the video quality or the audio quality, and that sometimes is just not the case. And so it's the panel's job to find that out beforehand, to understand whether there is a reliable broadband connection, and if there really isn't, then that means that, okay, maybe a completely virtual proceeding is just not going to be technically feasible in the context of this particular dispute and these particular parties. And so you have to plan accordingly.
Yeah, I completely agree. And I think there are sadly arbitrators who believe that they can simply delegate the whole thing and not worry about anything technical. That, as I said, I think is a mistake. Why? Because the technology, because it's used in in the context of legal proceedings, is always going to impact on due process, on the process itself, on the procedure. not necessarily if everything goes smoothly, but there are many intersections between technology and the procedure, and we deal with that in the report. We talk a lot about equality of arms, due process, and to me, if as an arbitrator, you do not understand that, then you're missing a trick, and this could lead to problems. So, it has an impact on the way the evidence can be presented, differences between parties. It can impact on the credibility of witnesses. I mean, it's been proven, I think we mentioned that in the report, that just not even a second of delay in cross-examination for the witness to answer a question could, if it's just caused by the connection, unconsciously will impact on the credibility, will create a sense of, lack of willingness or openness on the part of the witness. So there are a myriad of issues like that. And I think this is why, ultimately this, this whole, issue of the use of tech in arbitration justifies a whole report on it, because it's just simply not just a question of technology and cost. It's very much also a question of fairness. So I mean, if I may, I would really invite, not only arbitrators but counsel parties users to use the technology to their benefit, but also to their full extent, but also really understand the ramifications, trying to understand the ramifications of each of those applications, because the last thing we want is to have the technology having an impact on due process and ultimately on the validity of an award.
Mark, you're nodding, but is there something else you wanted to add?
No, I was just very much agreeing with Claire's example, and thinking back to what we said earlier is that if we identify some of these issues, we can address them, and really it takes a village, as they say. So counsel, tribunals, institutions really do need to flag these issues. So I just sort of made a mental note to myself when Claire gave the example, then if I see a witness being cross-examined and there's some latency in the response, I should address that. I should say, I'm sorry, Ms. X, it's taking a minute for us to hear you, and we understand that you're doing your best, or something, just to address the issue. So thank you for that, Claire. I think it's a good example of the type of thing that we need to be conscious of and deal with. But I keep coming back to most issues are addressable if we just identify them.
In fact, to that point, there was an interesting piece in the ABA, the American Bar Association Journal, that I read this morning while drinking my tea, about a family case where a woman, her kids ended up being taken away from her, but she had issues with her cellular connection, and she was representing herself. And the appellate court commented on how the judge did not inquire into some of those moments when there was silence and there was no response, that they didn't have an adequate backup plan in place because she could not connect by video, that she wasn't explained some of the procedures, like how to use a breakout room with stand-up counsel. So it really, I think, underscored a number of those kinds of issues. And those are things that I think we flag in the report in terms of being aware of them, in order to not overwhelm in dealing with the third-party service providers. I think part of the approach on the checklist was to recognize the tribunal, ultimately is responsible for the integrity of the hearing, but let's make it easier for the tribunal to convey expectations to parties and counsel when arranging things with the third-party service provider by giving some of these checklists that remind counsel to have conversations about these issues. Make sure everybody's on the same page, for example, about how exhibits are going to be called up and marked. And I raised that one. I was in a case, for example, where the third-party service provider was bringing up the documents, but was proceeding to highlight things in the document not directed by counsel. That, I think, we can all see David reacting on video there. Not something we want to see as counsel, not something we want to see as an arbitrator, but that's something that could have been avoided from happening in the first instance by having, taking the time to prepare in advance. And so while it can be frustrating that it takes the time, what we tried to do is to flag these issues in a ready fashion to be able to have a conversation with the third-party service provider in advance. So there's a specific, there are two specific checklists that deal with sort of relating to the third-party service provider. One, hiring them, do they have everything that we need? And here's a list of things to kind of ask so that you could have a junior associate take care of that, rather than it having to be at a partner level and say, just, take this checklist, go get me the answers. And then another one in terms of, immediate preparation for the hearing. So let me turn to ask a different question about remote hearings. One of the things that was interesting to me when we shared a copy of the report on OJMID, our media sponsor, was an arbitrator I know said, look, I find the checklists that you have for preparing for a hearing really very interesting. And one of the topics that you mentioned is dress code and a recommendation to use business attire. And the arbitrator said, I wish that there were a standard answer on this. So this isn't something that we surveyed. So we didn't have a survey opinion in making a recommendation of business attire. But we did make that recommendation. And David, I know you worked quite a bit on reviewing some of those checklists. So where do you stand on wearing a tie, not wearing a tie, business attire? Why do you think this matters and was something that we opted to put in the checklist after discussion?
Well, I'm the one wearing a tie today, so I guess I must feel that decorum in virtual hearings is still important. We were chatting and kind of joking before the seminar started that Mark doesn't have a tie on today, and there's a story behind that. But I think that it really depends on what the parties want to do. I mean, certainly I've been on panels where we have encouraged the parties to adopt a no tie rule, and that's partly for frankly for the panel's own comfort in what was going to be a weekend session in a case, and so it really is up to the parties. My own experience is that I have not seen counsel show up for a virtual hearing in an arbitration where they are dressed casually. And so I don't see, counsel in a polo shirt and that would be, what's visible on the screen. And so I think that there is a seriousness and a decorum in the process that continues, and maybe it's slightly reduced in terms of what one might experience at a federal courthouse. But on the other hand, it's not where, hey, we're just kind of sitting around in our, jeans and t-shirts and talking about this complex construction dispute.
Claire, do you think that there have been concerns about, the formality and gravitas kind of elements when you've been conducting remote proceedings? Has that sort of weighed on you?
I mean, I think I've always said to, my witnesses, you should wear a tie. But I do agree that if they don't, and if they appear in person, they will be able to build a rapport with the tribunal and effectively project their credibility in another way, because they're in 3D, they're in flesh, they're there. And it's true that when you're on the screen, there's just less visibility over who that person is. So that goes to the attire, but it also goes to the light, for example, the way, the position of the camera and all those things that, necessarily as an arbitrator, I wouldn't necessarily, as long as I can see a witness, I wouldn't necessarily say, look, I think, you've got quite a bad angle, or can you reposition a camera? But as counsel, I would definitely, we definitely pay attention to this. And what we noticed, interestingly, is that we, and there's this kind of almost like intangible factor. You just don't know why, but some people seem to come across better in video, and some other people seem, to come across less credible or less, likable. And sometimes you can't explain that. And so we have a lot of discussion, in our teams as to what would be best for a case for that expert, that witness. And of course, whether the other side's expert or witness appear, the kind of equivalent on the other side appears in person or remotely is a factor as well. But those are all very interesting, considerations for virtual hearings, as well as reading the room, looking at all three arbitrators is very challenging in the context of a virtual hearing. Whether in person you do that naturally and you would be able to manage and read, kind of try to get a sense from your arbitrators, which in virtual hearing is nearly impossible to do that, in my experience. The flip side to that is, if you with witnesses, you can have a team member just look at a witness and see, really observe all the reactions, which with hearing in person, it's harder to do that because you see the person from a bit further away. So those are all very interesting, I think, considerations, and I think they will, they're new, but they're here to stay. I think we will continue to conduct hearing on a at least hybrid basis. So I do think that we need to embrace them because they're here to stay.
Let's talk about the hybrid hearing, Mark. I think Claire, you were commenting really on the finer points of adapting to the changes that we have embraced, right? Fine-tuning advocacy, and part of that is what's the presentation of your witness, focusing on eye contact, appearance. I know that I pay much more attention than I used to about what mug I have if I'm going to drink out of it at a meeting, because I've had some interesting ones used by counsel and witnesses that were perhaps more eye-grabbing than they should have been. So, Mark, the hybrid environment, we're going to see more of those hearings clearly in the future. I don't think there's much debate about that. But what kind of things are you thinking about in terms of adjusting to that? Because it's very different, isn't it, from the hybrid environment in the past, connecting through Skype or using the big clunky cameras with one giant screen. What kind of things do you think we should be thinking about in the hybrid situation?
Well, I surely hope that we're going to be seeing a lot of hybrid hearings in the future. The case in point, at a case this week that had its initial case management conference, and we agreed that the parties would appear in person and all the other witnesses would appear virtually, and that also each side would have a right essentially to match what the other side did. So one party said, well, if they're going to appear in person, then I'm going to have if their expert's going to appear in person, then I want the right for my expert to appear in person, but I would rather that both experts appear virtually. So we're going to have to manage those kinds of issues. I think as tribunals, I hope we will encourage a lot of that. I think there are relatively few witnesses whose physical appearance in a room with the tribunal is critical. At the same time, I think, the baseline of party autonomy and control of the proceedings still is an overriding issue in many cases. So much as I say that I think virtual hearings are very effective, I would like to see a lot more hybrid hearings. If parties really want an in-person hearing, then I think we, by and large, can cajole and persuade, but we have to ultimately defer to the parties' wishes.
I mean, in that respect, Claire, are parties, a little bit at the whim of of the arbitrators. I mean, some of the arbitration rules have changed. When there was concern at the beginning of the pandemic about ability to compel a remote arbitration if there wasn't agreement. We saw changes to the IBA rules on the taking of evidence. So there's no longer, in theory, a presumption of an in-person hearing, but also no real standard for what factors are going to be considered. So if the parties disagree, are we sort of stuck with what the arbitrators personal views are? Is there any way to kind of predict in advance what decision is going to be made about whether to have a hearing? Or alternatively, do you think that there are clearly some factors that should be overriding considerations? I mean, Mark just said made a comment about witnesses and his thoughts about whether some witnesses need to appear in person. We have different views on those kinds of issues. So where do you stand on all of this?
These are tricky issues because, of course, what you might want to do as counsel might vary from one case to another. To me, the key is to know the rules of the game at the beginning. I find that because, of course, we're no longer really in a pandemic, but at the same time, COVID remains an issue for traveling, and then there's environmental issue, there's other considerations. The problem is that certainty is affected, right? And in my experience, there's been some hearings where, in some cases where, until the pre-hearing conference, there is just no people have no idea, no certainty about what the reasons to appear remotely might be, what the default rule is going to be. And I think for me that's a problem because you don't want to, for example, a party filing 15 witness statements and then later on say, well, we all appear remotely. Well, if that party had known at the beginning of the case that their witnesses would be expected to appear in person, maybe that they would not have filed 15 witness statements. And so I think at the beginning of a case, at the first case management conference, it's almost impossible nowadays in the environment that in our context, COVID wise, but other with other considerations, it's almost impossible to. And also at the beginning of a case, you have no idea who the witnesses are, where they're based, etc. So I accept that it's difficult to know at the beginning of a case, but I think at the beginning of the case, this is where the rules of the game should be set. For example, the default rule would be in person unless compelling reason, and compelling reasons could include X, Y, and Z. There must have been unforeseeable, whatever. But at least, I think that then the certainty and parties, expectations are managed, including in terms of cost, but also in terms of fairness.
David, what do you think about this?
Well, so there are two advantages to hybrid hearings. One is to save time and cost. The second is that they can allow otherwise unavailable witnesses to participate. And so really the question is, taking those advantages, are there problems? From a technical standpoint, you really have to be able to conduct the hearing in a way that would allow the witness to be seen, heard, and evaluated, just like a witness who is present in court. So there are issues with camera placement, how you're going to deal with documents, whether the remote participation is going to be by video or telephonically. I would certainly prefer video, but there also are, but there's a tension between having the remote hearing and what I'll call fairness or equal treatment issues. And I'll give one example in the interest of time. Let's assume you have one side plus the tribunal who are able to appear in person, but not the other side. Well, what do you do then? You continue the hearing if one side says, "Hey, we can't travel because of COVID," or we don't feel comfortable being in the room. And there are other permutations of that. What if you have one arbitrator who wants to appear remotely, and the other two arbitrators on the panel want to appear in person. How do you deal with a conundrum like that? And so there are, various permutations that, frankly, the panel or the parties are going to have to address. But the keys are, again, fair and equal treatment of the parties, and whether there's a benefit to having the proceedings conducted in a hybrid fashion.
Can I just say to David's last point that I think we as arbitrators have an obligation to speak up and communicate, essentially to say, if you're engineering this and spending a lot of money to have this witness appear in person for me, I just want to let you know that it's not going to help me. I would just as soon see this witness on a video screen. I think we need to communicate our preferences, particularly as the tribunal, if you're we're the ultimate audience for a lot of this stuff. And, counsel properly are thinking through in their lane, and they're thinking, what they think will be best for the tribunal, but the tribunal ought to speak up and say, I understand why you're thinking that, but actually I'd prefer to do it a different way.
So certainly going back to one of the beginning points that you made, Mark, about communication. Mm-hmm. So, and tying back into, early case management is, really importance on having conversations early and often about some of these issues. David, I think there are a couple of other advantages to hybrid hearings in some circumstances, which may also, or to the remote proceedings, in terms of availability for scheduling purposes. Often that, not just for particular, witnesses who might be needed for short periods of times, but that's certainly one factor. And on the flip side, if we're going to talk about objective circumstances and reactions to what helps or doesn't help, I will say that during the pandemic, I certainly have done a number of cases involving multiple time zones where there were inconvenient hours involved. Some of that doesn't matter. If I have to stay up till, midnight, I'm up till midnight anyway, and I'm happy to do something better. If I had to be up in the middle of the night, or if a witness, more importantly, was testifying in the middle of the night, some of that becomes less desirable. And shorter windows, that I did not find helpful. We were able to schedule one particular, I can think of a hearing where you had much shorter days, but then we went over a longer period of time. And while it made sense in the context of the pandemic, overall, I think that experience is less desirable than the intensity, personally, of a hearing.
The time zone issue is a real one, and I'll give one anecdote. In this past spring, of course, we've had the VIS moot, and there were various North American teams who advanced to the final rounds, and I think with one exception, all of those teams lost after a certain point, because they frankly were having to put their cases on as a practical matter, like 1 o'clock in the morning, New York time, with the European teams having an advantage that way, and so maybe maybe all the European teams were just better, but it is something that ought to give us pause if in the interest of moving things along quickly, we're forcing people to stay up in the middle of the night, or really to disrupt normal sleep patterns in a way that really just doesn't allow parties the time to adjust. That does seem to be a fairness and equal treatment issue.
So lots of factors that build in there. One of the other things that the report focuses on in the hybrid context, obviously we have the fairness kind of issues of who appears. My guy appears, but your guy doesn't appear, that Mark kind of flagged, or, tribunal members being present and in front of counsel or not. Those are some of the fairness kind of considerations that we flag. But one of the other things I think that's different about the hybrid environment is the kinds of technology that we have been using. We've gotten used to Zoom. Like, we're on this platform now with, in similar platforms where we're using the laptop desk camera as opposed to the big giant screens with the bulky video, and screen placement makes a big difference. I don't think we've really talked too much about adapting our old hearing rooms for the new normal. If we have a number of witnesses participating on camera, are we setting up hearing rooms the same way that we did before, where everybody has to look at one kind of screen? Or are we paying adequate attention to those kinds of arrangements to make sure that the witness has, a feeling as close as possible to be able to see other people in the room? How do we manage some of those concerns? And are we focusing on that when we're making arrangements for hybrid hearings? Claire, is that something that you've focused on, or has been an issue in converting to the sort of hybrid format? In particular, you can think of people appearing from different conference rooms, not all together, and trying to manage some of those dynamics. And any comments?
I think the answer, Steph, is that we're just learning as we go, and the checklists are great, and I've received a lot of good feedback on them. But there's always going to be issues like that, position of screen, and that you can adjust. There's always going to be a new setup, different setup, different witnesses with different infrastructures. You know what I mean? It's we're bound to have to learn as we get on. But you're right. It's just more and more things to think about.
So
I'll just observe, Steph, that the AAA has just built out the former NIAC space with these issues in mind. So they have voice-activated mics and strategically situated cameras. So people are thinking about that very issue.
So on that note, it's 1244. So let me first give you the second CLE code. So the Cle Stop Code is 313, and the CLE Start Code was 312. So those are two CLE numbers you should have if you're going to try and get CLE from Brian Cave. And there are a lot of tricky issues that I think we've talked about today and canvassed a little bit. There's further discussion in the report, but really did want to end on a positive note and emphasize that the way in which we've approached a lot of these issues is to try and flag them, but do it in a relatively straightforward, accessible way, so that those who've been using technology deeply integrated into their practice are equally comfortable reading the report as someone who has no real background, and referring to the checklists and to other well-developed resources that are out there so that it's digestible. It doesn't have to be overwhelming. And it can seem like it when we talk about all the different things that one has to keep in mind, but that's one of the reasons why we really tried to use as many checklists and tool reference points, because you shouldn't have to memorize these things. And there is a lot to keep track of. And these are tools that we hope that that you can take advantage of and incorporate into your practice. And we definitely would love to hear your feedback going forward, because it's certain that this is something, as Claire said, we're learning as we go. We keep improving. So it's important that as a community, we continue to sort of improve on those practices. And with that, I think we are at the end of our time. David, Claire, Mark, if there's anything you want to say as a final note, please jump in.
Thanks for joining us. And if you do have suggestions, you can contact any of us or the ICC.
Thank you. And same here. We can't wait to hear your feedback on the reports. I hope.
Yes, I agree. Thank you. Thank you, everybody. We do hope it'll be a living document. So please let us know your thoughts.
Okay. Enjoy the rest of your day. Bye.
All right. Bye-bye, everybody.